Our next case is Schafer versus Kent County. Good morning. This is a 20-minute grant, 20 minutes per side and 5 minutes for amici. You may reserve time for rebuttal, but we ask that you keep track of that, and you may begin when you're ready.
Thank you, Your Honors. May it please the Court, Matthew Nelson on behalf of Kent County, and I will try to reserve 4 minutes of time for rebuttal. Within a few months of the Raffaelli decision, the legislature unanimously approved amendments to the General Property Tax Act to address this court's ruling, and the governor signed those bills. The legislation made the new statutory remedy for claiming surplus proceeds retroactive only if this court ruled that its Raffaelli decision is retroactive. In other words, the other branches saw this court's decision as a change in the law that may not be retroactive and planned accordingly. More than 3 years later, that question is now squarely presented to this court in this case. The effect of this court's decision will apply to the counties, will apply to all the counties in the state, not just Kent County, and affect cities, villages, townships, and the services they provide, not just counties themselves. Consider the effect of retroactivity on 2 counties. For the period of 2013 through 2020, Wayne County's surplus proceeds liability exceeds $120 million. For the same period, Lake County's liability is $2.3 million, a proportionally greater liability based on county populations. Both counties have zero-sum budgets. Additional expenditures must be offset by cutbacks or chargebacks to cities and townships, all of which will affect government services for county residents. And it's because of the aggregate effect on counties like Wayne and Lake, which relied on a properly enacted tax statute in good faith, and the effect that it's going to have on residents throughout the state, that this court should give Raffaelli limited retroactivity and specifically apply the decision only where the parties raised and preserved the issue before Raffaelli was decided, in cases that were filed and pending when Raffaelli was decided.
Okay, so
Let's jump in.
Yeah, so let's start with, we know when we're going prospective. We know what full retroactivity means. Let's just jump right into limited retroactivity and how this court can or could apply that here.
So with regard to limited retroactivity, I think the place to start is I think it's important to define the parameters of what we're talking about, because I think that is what has led to the confusion in various decisions in the Court of Appeals, in the lower courts, and perhaps in the decisions of this court. Specifically, I would submit to the court that retroactivity should be viewed to consider the application of a decision, an overruling decision, to operative facts that occurred before that decision, such that claims that accrue before a decision would fall within the retroactivity situation. Claims that accrue after would be with regard to prospectivity, without regard to when the lawsuit itself is filed. And I think that's probably the key point of clarification with regard to what we're talking about with regard to retroactivity. I think retroactivity has to be applied with a discussion of the operative facts on the ground, and not with regard to just when a claim was filed, or just when a lawsuit was filed. Then turning to this court's jurisprudence and what this court can do with regard to limited retroactivity, I think this court has already established a three-factor analysis in Pahutsky that allows this court to tailor to the specific circumstances of unusual cases a rule of less than full retroactivity. And that can range from retroactivity where the case only applies to the parties that were before the court to full retroactivity, with limited retroactivity being anything less. And so here, what we're asking this court to do is to give the language that it is used to designate limited retroactivity, that the issue has been raised and preserved in cases already pending at the time of the decision, the plain language effect of those terms. The overruling decision applies only to cases where the issue was raised and preserved and were pending at the time of the decision. The reason to do so here, I think, is threefold, applying those Pahutsky factors. First, the purpose of the rule was to terminate the practice of the state of using strict foreclosure in the tax foreclosure practice. Now, strict foreclosure, I think, is a term that this court didn't use in Raffaelli, but in cases that have come since then has become the term that's been used for a situation where the foreclosure does not result in any surplus being returned to the former interest holders in the property. And so the Raffaelli decision's purpose was to terminate that practice, and it has. The legislature has terminated that practice through the amendments to the General Property Tax Act. Then the court would turn to the two equitable considerations in Pahutsky of reasonable reliance and the administration of justice. Here, the reasonable reliance is demonstrated by the fact that strict foreclosure was the rule in Michigan, not just since 1999, when the immediate past version of the General Property Tax Act was in effect, but all the way back to 1893. Because under the regime that existed before the immediate past regime, there was a situation where private parties would purchase the tax liens and then foreclose and retain all of the surplus without any payment back. So there was strict foreclosure in Michigan with regard to tax foreclosure all the way back to 1893. This court and the treasurers were able to rely on that back to that point. I'm sorry if I missed a question. The treasurers were entitled to rely on the constitutionality, presumption of constitutionality of the tax statute, especially with that history. Furthermore, I think, as this court is aware from the argumentation in Raffaelli, other states had adopted the same approach. Raffaelli was, frankly, at the beginning of a tidal wave of change with regard to this issue that is now swept across the entire country as a result of the Tyler decision. But at the time this court made its decision in Raffaelli, there was one other state Supreme Court that had addressed the issue. That was in 2018 in New Hampshire. And before that, the federal courts and the Court of Appeals, so the federal courts in Michigan, the Sixth Circuit, and the Court of Appeals in this state had all upheld the very practice that was rejected in Raffaelli.
Mr. Nelson, can you, I understand your position that you say limited retroactivity for the reasons of the effect of that, and that's balancing the fact that we are going to be denying some individuals a claim, right? We're balancing that sort of thing. What do we do with the fact that the U.S. Supreme Court in Tyler said it applies fully retroactive?
So the U.S. Supreme Court obviously has adopted a jurisprudence of full retroactivity for all its decisions. What that means here is not as my colleagues might suggest, that the issue here is moot, but rather that in our parallel system, individuals who have surplus proceeds claims have those claims arising under federal law under 1983 and also under state law. With regard to the federal law claims, a decision that Raffaelli is not retroactive or has limited retroactivity would not affect the availability of a 1983 claim, and the 1983 claim could be pursued for a period of time of up to 3 years. The statute of limitations is 3 years.
Is that relevant sort of to the equitable considerations that even though if we apply it limited retroactivity, it is not leaving some of those who perhaps are without a remedy under Michigan's Constitution, they would still have their federal claim? I mean, is that relevant, is that a relevant consideration in this sort of balancing the equities?
I would say yes, Your Honor. I would say this is a somewhat unusual case in that context. Usually when this court addresses retroactivity, that's not the case. But here, if you look at the totality of the facts, and we're dealing with the court's inherent power, so there's no reason not to, we have a situation where the effect of a non-retroactivity decision is frankly to shorten the limitations period from 6 years, which is the presumptive statute of limitations for a inverse condemnation claim, down to 3 years, which is the statute of limitations on a 1983 claim. And then, of course, the claims are channeled or potentially channeled into federal court.
Counsel, I tend to agree that the Pahutsky factors are fairly easy to apply, not too complicated. The case law has evolved over time. Your briefing did a great job explaining the confusion between what sometimes is called limited and sometimes called full, even in this case, how that's applied. If I were to agree with you and say, yeah, we just have to apply Pahutsky here, do we have to deal with, is it Develers and Hathcock and some other cases that sort of then talked about it's a new law versus we're returning to an old law, or do we just distinguish? What do we do?
I think that what De Villers and Hathcock demonstrate is that this court can say, although we're returning the law to the way it always has been, which I think is the classical formulation of what this court does, in this particular case, because of the unique facts of the case, we're going to give it limited retroactivity, just as this court did in Hathcock and De Villers. So I don't think that this court has to overrule those decisions. In fact, I don't think that there's any decision. I think that a clarification with regard to limited retroactivity would not require this court to have to specifically overrule any decision, but just to say, we're bringing this together and we're trying to provide a comprehensive discussion for the bench and the bar.
Yeah. And I appreciate your plea for us to try to set some clear rule, because we can acknowledge it's confusing, so.
So turning to, I think I've talked about reliance. I haven't talked about the administration of justice factors, but we went through them in our briefs. The one thing that I would try to point out, and I was chided by the Michigan Association of Counties and County Treasurers a bit for this, in that we decided to understate the potential liability statewide because we didn't want to be in a position of coming in here and being accused of being Chicken Little and suggesting that the sky is falling. We said in our briefing it's $150 million. Based on further analysis, we think that the number is at least $250 million just on surplus liability. So how do we get there? For the west side counties and the UP counties, the total is more than $60 million for the period of 2013 to 2020. For Oakland County, it was
What were the dates again? I'm sorry.
2013 to 2020, which is the period of time that several class actions or proposed class actions have covered, and I'll reach a further point on that in a moment. For Oakland County, the amount was more than $40 million. As I indicated earlier, the amount for Wayne County itself exceeds $120 million, and that leaves the counties that are covered by the state as the foreclosing governmental unit, and I believe it's about 20 counties on the east side of the state. So when you total those, we anticipate that the liability just from 2013 through 2020 is more than $250 million for surplus proceeds. That doesn't include liability with regard to properties that were transferred via the right of first refusal to other governmental units, and that doesn't include liability for the period of 2008 to 2012, which some cases suggest, some lawsuits are suggesting should be the appropriate measure of time. And
Can you explain to me how they get back to 2008?
Sure. So while we don't endorse this approach,
Sure.
the methodology that they use is that the Wayside Church case, which was a putative double class action. So it was a plaintiff's class and a defendant's class. The plaintiff's class is easy. The defendant's class was they sued one county and they said, but it's a class of defendants of all counties in the state. That was filed in 2014. 6 years before that is 2008. and the filing of a statute of the filing of a class action, sorry, I missed an intermediate step. The filing of a class action tolls
that potential class,
Right.
right?
We think there are numerous problems with that theory,
Sure.
but the fact of the matter is we're fighting with
The
it.
potential liability that you might face might go all the way back to 2008.
Correct.
Or no, all foreclosing units, okay.
So I have about 2 minutes before I promised I would sit down. Unless the court has questions, I'd like to just for a moment address what we anticipate the effect of a limited retroactivity ruling would be both here and in other cases. So here, a limited retroactivity ruling would mean that Schafer's state law claims that are dependent on Raffaelli, and we think that's all of them, would have to be dismissed. This court could either do that or could remand to the trial court for that purpose. To the extent that the court doesn't give limited retroactivity to the decision and instead gives it full retroactivity, then the exclusive remedy from 78T comes into play, and that becomes an issue in the state court. In other cases where the claims were raised and preserved in cases that were filed before Raffaelli, if this court adopts limited retroactivity, then the parties may still bring their federal claims and their state claims should be dismissed. If this court instead gives full retroactivity to the decision, then in each of those cases, the lower courts will need to address the exclusive remedy provision in 78T and how that applies, which my colleagues from the Department of Attorney General will be addressing shortly. Unless the court has more questions for me at this time, I will reserve the balance of my time for rebuttal. Thank you.
Thank you.
Good morning. May it please the court, Ted Seitz appearing on behalf of the Michigan Association of Counties and the Michigan Association of County Treasurers. We appreciate the court granting us the opportunity to provide their our perspectives on these issues in this case. However, given the court's question and the presentation from Kent County, we would actually like to just take questions if the court has any, and then speak in the next case before the court, which is the Hathen case.
Any questions?
It would really be about the legislation that was passed and its curative effect, and the fact that the Michigan legislature had some hesitancy, obviously, in full retroactivity or prospectivity, and kind of knew the impact of the Raffaelli case, and that is why they left it to this court's discretion within the statute and the process they created, the curative process in 78T.
Okay, thank you.
Thank you.
Good morning, Christina Martin for Appellees Matthew Schafer and Lily Huckleberry. May it please the court. Kent County took Matt Schafer's home and sold it for $46,000 more than he owed in taxes, penalties, interests, and fees. And it took 80-year-old Lily Huckleberry and her late husband's home and sold it for $27,000 more than she owed. The county kept all the money from both sales as a windfall at their expense. This court in Raffaelli and the U.S. Supreme Court in Tyler held that when the government takes such a windfall, it violates the constitutional mandate that the government pay just compensation when it takes private property for a public use. Both decisions, both Raffaelli and Tyler, also said that when the government does this, it violates the fairness and justice purpose of the just compensation mandate. Kent County's argument against full retroactivity rests on the opposite premise, that to have to pay back people like Ms. Huckleberry and Mr. Schafer, it would cause injustice. And essentially, this court would have to reject its own decision in Raffaelli, the U.S. Supreme Court's decision in Tyler, several Sixth Circuit decisions, and a lot of other opinions across the country at this point. The county warns about the expense of paying back what it's unconstitutionally taken, but Kent County's it's available financial document that we cite on page 26 of our brief, and we would ask the court to take judicial notice of. That document, it's their comprehensive financial report. It says on page 108 that resolving these kinds of cases, quote, will not have a material adverse effect on the financial condition of the county. You may wonder how that might be, and if you look at the balance of the revolving tax fund, which grows each year, you will see perhaps that is why it will not have a material adverse impact. It's also much less than the county's entire budget.
But obviously, we're not just talking about one county here, right? I mean,
Right.
ultimately, our decisions affect the state, so is that true of every county?
I mean, they offered nothing in their briefs other than a vague assertion about the total liability dating all the way back to 2008, and they give that entire liability. They can only try to ask this court to get out from 3 years of that. We don't even know what those 3 years would be. They have not presented any figures. They've not given us anything specific that we can respond to. I would think if they're trying to get this court to weaken the takings clause, the just compensation mandate, that they would be a bit more aggressive in providing evidence that this really is, the sky's going to fall essentially if they have to pay back what's been taken.
Well, I think there has been an explanation to explain why that's difficult, right? I mean, you have other liens were on the property. It's a case-by-case determination. Every county's different. I mean, I heard some explanation that it's difficult to come up with a number, and obviously if, depending on what we find, if they have to do that calculation, I'm guessing they will. But I mean, I think we can guess it's probably a pretty big number. Would you agree with that?
I mean, for you and me, yes. But for the counties, compared to their overall budgets, their revolving tax fund, if you look at their financial statements, if they'd given me a county other than the county we're dealing with here, I would have happily looked at their publicly available financials. But ultimately, this is all, the problem with all of this is that they're essentially asking this court to add a loophole to Michigan's takings clause. So instead of reading private property can't be taken without just compensation, unless, it would read as unless the government is going to use it for some, tax collection, or unless, we didn't know that this was a taking when we did so and it's going to be expensive to pay you back. This court should not adopt that weakening of the Michigan takings clause.
So counsel, I mean, I think we all know, based on what this court found in Raffaele, that there was this, windfall to the counties. I think Raffaele speaks to that. What do we do about the reliance here? I mean, what choice, if you're a county treasurer and this is what the law says I'm supposed to do, what were they supposed to do instead?
Well, I mean, what a lot of the counties did was actually just hold on to the money in their revolving tax funds. And, there were lawsuits that were filed many years ago. Raffaele was filed back in 2014, and it was thrown out of federal court for lack of jurisdiction. And that's why it worked its way up in the state court.
Right, but several, all over the country, this sort of tax collection scheme was sort of upheld, so I'm assuming there was reliance on that. I'm not saying there weren't challenges, but they didn't succeed, did they?
There shouldn't have been reliance interest, though, because this court held in Dean back in the 70s that plaintiffs, like our clients, have a viable claim for unjust enrichment when the government takes your property for more than what you owe and sells it for more than that. That's been on the book for decades. So that it wasn't a reasonable reliance. Our clients have a claim for unjust enrichment as well as they do for a takings claim. It's just, you're not supposed to go to equitable claims when you have a claim at law. If this court does decide to walk through the retroactivity analysis in this case, that analysis overwhelmingly favors retroactivity, which is why the county is trying to get the court to reinvent the retroactivity doctrine. The threshold question is whether a decision clearly establishes a new principle of law. And this court in Raffaele and the U.S. Supreme Court in Tyler and the Sixth Circuit in Hall all recognized that the principle at stake here goes back 800 years. This court in Dean recognized the same underlying principle that a former owner gets to seek the excess proceeds from sale of their property. So that factor, whether it's new, clearly weighs in favor of full retroactivity. And you could stop the analysis there, since that's the threshold question. But if you want to walk through the other elements, each of those elements overwhelmingly favor full retroactivity as well. The purpose of Raffaelli is to protect constitutional rights. Surely that must weigh in favor of full retroactivity. As for reliance interests, as I said earlier, that wasn't a reasonable reliance given this court's decision in Dean. And the county has argued that this decision sort of came out of nowhere. It was the beginning of a tidal wave. That's just not so. The New Hampshire Supreme Court had a decision. The Vermont Supreme Court from the 70s had a decision in a case called Bogey. We cited in our brief. There was a great decision in the DC District Court. And there was a decision in the Mississippi Supreme Court and the Virginia Supreme Court, and there were a number of other state Supreme Courts, again, cited in our brief, that talk about the injustice that would be caused by this sort of thing, that go out of their way to interpret statutes like this to avoid a forfeiture.
So, but going back to the foreclosing units, at the time, I understand there were challenges to it, and, maybe all the way back to the Magna Carta, we should have seen this, and, but the foreclosing units in Michigan were bound to follow the statute, correct? And the statute did not provide a mechanism for them to, I understand your position that they could have just kept the money, because someday, we might issue a decision like Raffaelli. Did they have an ability to not commit the taking, to not return the surplus under the statute?
They had the ability to take the property. The Constitution required they pay just compensation, and I didn't see anything in this. I mean, I can't tell you whether Michigan would have gotten them in trouble or not, right? They could have joined us. They could have joined us in Raffaelli and said, yes, this is a taking.
So
we want to pay people back.
Statute says I have to do this, but you know what? I don't think it's right. I'm not going to follow the statute. I'm going to return the money.
I don't know if they could have done that, but what I can say is they could have joined us in arguing that this is unconstitutional. I don't see why they did it. I mean, obviously, there's practical reasons.
That's not remedying the taking itself, right? The taking would have been to return the money to the
The taking still would occur, but then to pay just compensation would remedy the taking, right? So what I'm saying is they still would have had to take the property, but by paying just compensation, they could have been making people whole and stopped doing it going forward in the future. But I mean, I don't want to get totally sidetracked by this. The bottom line is that it was unreasonable for the county to be relying on this. And in fact, many counties did have large balances accumulating in their tax revolving funds. They didn't just go out and spend it on whatever. There are at least one county that I know of that did take some of the money into their general budget, okay? But most of the counties, as I understand it, kept the money in the revolving tax fund. And that shouldn't be the question, because what you're talking about here is essentially like the county has a lot of money compared to our clients. Most of these people lost absolutely everything when they lose their home. These properties are sold at bargain basement prices and auctions. They're not asking, give me the sky. They're not asking for a realtor sale. They're just asking for the remaining surplus proceeds from the sale of their property. They're asking for what's constitutionally required, which is, I don't think it's actually asking all that much. So I think the reliance interest has to overwhelmingly favor full retroactivity, because our clients and most Michiganders did rely on the idea that the government isn't going to take more than what's owed. I understand it was in the law books, but most people in America didn't think this was possible, which is why you have groups from across the spectrum with all sorts of different viewpoints that joined as amicus in this case, and Raffaelli. And back in Tyler, there were 40 different groups joining in support of the property owner there, and all of them expressed some level of shock or outrage that this would happen anywhere.
Council, could you address, I believe it was brought forward, the notion that Michigan has the highest rate of foreclosure?
I don't know. I mean, that's possible. It wasn't in the briefs, but what I can say is if Michigan had an incentive, if there were counties with an incentive to foreclose because they could get a windfall, that would not at all surprise me.
Thank you.
I struggled with the whole notion of retroactive versus limited retroactivity, and I went outside of Michigan and looked at SCOTUS, and I became more confused when I looked at Linkletter and Chevron. I think they've since tried to clarify. Would it be fair to say that the Supreme Court now, what they understand to be full retroactivity is what was described as limited retroactivity?
So what the Supreme Court's rule now is in Harper versus the Virginia Department of Taxation, which is that if they apply it to the parties before them, then it is fully retroactive as to all cases pending and all matters and all events regardless of when they happen. So in other words, if you're not barred by res judicata, you can recover.
It applies to all cases that are not yet final at the time of the decision, or all
Under-
cases that are not yet filed at the time?
Under Harper, that seems to be the case, but it looks like under this court's jurisprudence, it would be all matters filed, not yet final, and where the matter hasn't been waived. In other words, if you didn't bring it up in your trial court and you're up on appeal, it's too late to add the claim at that point.
Do the plaintiffs before our court presently all have viable claims under Tyler, federal claims?
I believe so, but until we actually get a final unappealable judgment on that, I think it's important to preserve their state constitutional claim as well. As for the administration of justice, I mean, I've harped on that a little bit, maybe too much at this point, but I would just remind the court again that Tyler, Raffaelli, and a number of other cases, including Hall versus Meisner, all know that fairness and justice requires paying back the just compensation. Unless the court has further questions, I would just argue that justice requires that the county pay just compensation. The sky will not fall by asking the counties to pay what they've taken. And actually, I will point the court to the U.S. Supreme Court's decision in Arkansas Game and Fish versus United States, because I think it's apt. In that case, the court said, time and again in takings cases, the court has heard the prophecy that recognizing a just compensation claim would unduly impede the government's ability to act in the public interest. We've rejected that argument when deployed to urge blanket exemptions from the Fifth Amendment's instruction. While we recognize the importance of the public interest the government advances in this case, we do not see them as categorically different from the interests at stake in myriad other takings cases. The sky did not fall in those prior cases, they're citing Cosby. And today's modest decision augurs no deluge of takings liability. I'll just say this, the decision here, just doing what this court does all the time with constitutional claims and requiring full retroactivity won't cause the sky to fall either here.
Counsel, is it your contention that this has become kind of baked into the counties and their budgets?
Is it my contention that it's been baked into their budgets?
Has this become just a part of their annual or actual budgets?
Taking the surplus proceeds or paying just compensation after the fact?
Both.
I guess we'd have to look at it county by county. As for Kent County, they have what it appears based on their public financials, they have the money sitting in the revolving tax fund.
Okay. And again, going back to the initial question I had asked about where Michigan kind of rates in this, it was my understanding that this is kind of an issue that Michigan has, that basically Michigan does have kind of a high rate of foreclosure in comparison to other states as it pertains to this problem.
Again, I'm not sure if it's higher than other states or not, but again, if you have an incentive where the government can get a windfall if they are foreclosing, you're probably going to get more foreclosures in some places, unfortunately. Incentives matter. And that is one of the reasons why we would ask you to give full retroactivity to the decision, because the alternative is that you would create an incentive for counties, as long as there's not an opinion directly on point that's controlling in this jurisdiction, let's go ahead and risk it and take private property without just compensation. I don't think that would be a good situation to create that sort of incentive where you open up the takings clause to this new limited retroactivity example. And I want to point out the government has not given a single example of a situation where there's been limited retroactivity to something like a just compensation claim. And I think there's good reason for that, which is that the the Constitution is non-negotiable. So we would ask this court to affirm the Court of Appeals decision, or alternatively hold this case was improvidently granted. Unless there's any further questions.
I don't see any. Thank you very much.
Good morning again. I want to start where Sister Council left off with regard to incentives. There's clearly no incentive for Michigan's county treasurers to foreclose, to keep surplus proceeds at this point, because the legislature specifically addressed this court's decision in Raffaelli and amended the statute with the help of Sister Council's organization. There's no need for this court, if it gives limited retroactivity to Raffaelli, to reject any cases in any other state, because the underlying decision of Raffaelli doesn't change. Instead, what the court does is act separately with regard to its inherent authority to tailor the effects of Raffaelli to address the various issues that have been raised and the impact that Raffaelli would have on this state and its residents. The comments with regard to the overall budgets of various counties are interesting because it demonstrates the fact that they point to the fact that for many counties and for many municipalities, the money has been spent, and you would have to reduce budgeted expenditures somewhere to pay the liabilities going back for the full period of time. Turning to reliance and the issue of Dean. This court in Raffaelli spoke of Dean inherently, including identifying a common law right to this surplus. And by inherent, the reason that the court said inherently is because nowhere in Dean does the court actually say that. I think that I don't disagree with the court's conclusion in Raffaelli that it was inherent, but to suggest that that something that is implicit in Dean should have been obvious to foreclosing governmental units with regard to a practice that had been in place for a significant period of time and with regard to a statute that had been repeatedly upheld seems to be a stretch too far.
If this court were to rule against you, what would the overall realistic implications be on your county?
On my county?
Yeah.
My county would face the full liability for the surplus proceeds with regard to any claim that succeeded, and it would end up paying those.
And what would what I'm trying to understand is
How would they pay it?
How would they pay it, and what would the overall effect and implication be?
I anticipate that they would pay it either out of litigation reserves or out of other reserves that the county has. Kent County is not the poster child, I would say, for the situation where giving Raffaelli's ruling full retroactive effect is going to have the most severe consequences. I would submit that Lake and Wayne, the two counties I identified at the beginning of my argument, are going to experience far greater negative effects. And there are many other counties like that have significant liabilities. So for example, to my understanding, for the period of 2008 to 2012 to 2013 to 2020, I've got to get my dates right. For that period of time, on the western side of the state, Muskegon County has the greatest liability for surplus proceeds. And so, yes, Kent County, my client here, is not the county that suffers the worst effects, but because this court's decision applies statewide, there are various other counties and various other municipalities that will be hard hit.
So I would assume the impact is they pay it, they have to pay, obviously, they either have to raise taxes to pay it, they have to cut services to pay it, or dip into reserves to pay it. Some counties have reserves, some don't have as big of reserves, which of course affects bond ratings. Is that a fair assessment?
I think that's the case, although raising taxes is, for many counties and for many municipalities, not an option because they've hit they're capped out. And so.
So it's cut services.
It's cut services or other expenditures.
How do you respond to Ms. Martin's argument that some counties, and maybe Kent being in this position, that you have this, the rolling fund, and that it's not, the money's not spent, it's sitting there, and this is just what counties should have done? How do you respond to that?
So Justice Welch, two responses, if I may finish. Two responses. First, with regard to funds in the revolving, the surplus proceeds sitting in the revolving fund. There are surplus proceeds that were surplus after the counties paid the property taxes for properties that did not sell, and so they had to recoup the property taxes. So every county used a portion of the surplus proceeds to cover property taxes that had been advanced to local taxing units that had not been recouped through the sale of tax foreclosed properties that were either sold at a loss or were not sold at all. And so every county has spent a significant, more or less in various counties, portion of the surplus proceeds. They never essentially were accumulated in the delinquent tax revolving fund. With regard to the idea that the counties should have anticipated and either banked this or somehow found a way around the statute, the fact of the matter is, I don't think that the case law, especially given that in 2015, the Wayside Church Challenge, which we talked about earlier, was dismissed by the district court. In 2017, that dismissal was affirmed on other grounds by the Sixth Circuit. And in 2017, the Court of Appeals rejected the arguments that were advanced, that were ultimately adopted in Raffaelli, suggests that the treasurers were unreasonable in relying on the constitutionality of a statute that had been in effect since 1999 in the strict foreclosure process that had been part of Michigan tax foreclosures dating all the way back to 1893. Unless the court... Oh.
I have one more question, and real quick. Your position, you said earlier, was that if we agree with your position and apply limited retroactivity, then Mr. Schafer and Mrs. Huckleberry's claims should be dismissed. And maybe this isn't fair because it's really about the next case, but I suspect that you're pretty familiar with those issues as well. If, as some have argued in that next case, say we agree with the position that some form of equitable tolling applies to application of the statutory remedy, would Mr. Schafer and Mrs. Huckleberry be able to take advantage of that equitable tolling, even though their suit here would be dismissed, but they're not foreclosed of a remedy perhaps under the statute, assuming all of the things happen that are being advanced in that case?
If this court were to, if the court were to grant limited retroactivity here, I think the answer would be no with regard to the availability of a remedy under 21178T, because presumably the retroactivity of that statute would be the same as the retroactivity of Raffaelli and not greater. But even assuming that that wasn't the case and that 78T were available, the legislature has provided for a 2-year statute of limitations or a statute of repose with regard to claims, the 78T claims. And consequently, you would have to go back from this court's, I think you would have to go back, it's this court's decision. If you would go back from July of 2020, 2 years, you'd get to 2018, and the claims here were filed in 2017. Now, I suppose there are various tolling theories that the plaintiffs here may advance as to suggest why it is that they would still be able to fit within that, but I think that those are issues that probably would have to be sorted out in the lower courts because they will require undoubtedly extensive additional briefing.
Okay. Okay, thank you.
See any other questions? Thank you. Thank you both. The case will be submitted.
Thank you, Your Honors.